Representative Holclaw? Representative Love?
Here.
Representative Manis?
Here.
Representative Shaw?
Here.
Representative Williams?
Here.
Representative Wright?
Here.
Chairman Crawford?
Present.
Chairman Rudd? Chairman Rudd, you
Here.
have a quorum.
Thank you. Before we begin, many of the members. Seeing none, we can begin the hearing bills today. First up today, first of all, we have 7 bills on the calendar. Let's begin with HB 1179 by Chairman Moody.
Representative Moody, you have a motion.
Have a motion? Have a second? Please tell us about your bill.
Thank you so much, committee. Good to be before you. I don't think I've ever been in this committee before.
It's a fun committee. You'll
So
love
I
it.
knew, I could tell. I already knew. Well, thank you for taking this up for me. What this bill would do, this legislation would apply the same penalty to officers of a PAC with unpaid civil penalties for reporting or contribution violations that are applied to the individual candidates. As a matter of fairness, we want to ensure that PACs are treated in the same manner as candidates. And with that, I'd appreciate a yes vote.
We have any questions on the bill and its meaning and intent?
Motion.
Seeing none, I hear a motion. All those in favor of the bill say yes.
Yes.
All those opposed say no. No. Bill passes.
Thank you.
You move on to, I believe, full committee, full local.
All right. Thank you
Thank
so
you.
much.
Let's see, next up will be HB 1098 by Chairman Baum. Guess he's chairman. Motion and a second.
Thank you, Chairman
Say about your
Rudd.
bill.
Tennessee statutes currently require county election commissions to provide absentee voting procedures at assisted living nursing homes. It is not clear from the statutes whether the residents of the independent living units on those campuses can participate in these early voting procedures. Some counties have allowed them to and some have not. This is a bill that would make it clear that the residents of the independent living units are permitted to participate in the absentee voting procedures on site with the assisted living residents.
And I think that is clear that this is not just extending the election commission to go to assisted living facilities, but where they're already on an existing facility or attached to a nursing home that's already, the election commission's already going out to.
That's right, and the independent living units must be on the campus.
Okay. Any questions? Representative Shaw?
Thank you, Mr. Chairman. I just wanted to commend the sponsor for bringing this. I think it really helps with our especially elderly people and make it easier for them. In this case, you're not really changing any laws, just making sure that they get that opportunity. And I thank you for that. I know my constituents would like that. Thank you.
Thank you. Many of the independent living residents are elderly and have trouble driving as well.
Any further questions on the bill? Seeing none. All those in favor of the bill say aye. Aye. Opposed, nay. Bill passes and move on to full local government.
Thank you all.
Next up is item number 3, HB 0609 by Representative Halsey.
Thank you, Mr. Chairman, and thank
We
you,
have a first
committee.
and a second. Tell us about your bill.
All right, this is a bill that deals with equal access for minor parties. Tennessee State Constitution, Article 1, Section 5 states very, very plainly that the election shall be free and equal. And I don't know if you knew this or not. I didn't really know this till I started digging around in it. But as a Republican or a Democrat, the way state law is now, all you have to do when you want to run for any state office or a statewide race, all you got to get is 25 signatures. If you want to run on a minor party, and all that means is, beside your name, you want the party that you're running under, like a Green Party or Constitution Party or Libertarian Party. Under existing state law, if you want that, you have to get 56,083 signatures. Now, that's what current law states right now. So that's because our state law says that if you want to run as a minor party, you have to get 2.5% of the last governor's race, total number of people that did it. And that's how many signatures you got, and that's why you get that 56,000. So, of course, that's just about unattainable for somebody. Now, if you want to run as an independent, you only have to get 25 signatures, but nobody knows what your platform is because there's no party to identify yourself with. You're just independent. So what this bill does is it says let's reduce that 2.5% down to 0.5%. That computes to about 12,000 signatures. Now, to me, that's really not quite equal and fair, but to minor parties, they say that's attainable, and they could do that. So they're willing to say, yeah, let's go down to 0.5% and allow us on a statewide race to only have to get 12,000 signatures. Now, that puts us closer in the ballpark with other states and what they require for minor parties. If you're just looking around us, Florida doesn't require any signatures for a minor party. Kentucky requires 5,000. Louisiana requires 1,000. North Carolina requires 11,700. Missouri requires 10,000. Mississippi doesn't require any. South Carolina requires 10,000, and Virginia requires 10,000. So 12,000 is much closer to that, and it's attainable. Right now, with the way our state law is written, we're the third worst state as far as how many signatures you have to get. So this bill does two other things. Under existing state law, if you get your 56,000 signatures and you're running a statewide race, if you get 5% of the vote, you can be declared in and labeled a minor party. And if you are labeled as a minor party during the next election, you don't have to get to 56,000 signatures again because you got the label. But if you get less than 5%, you've got to get 56,000 signatures again if you're running the next election. So this bill would change that number from 5% down to 1% and lower that retention. The third thing that it does is under existing law, if you get 5%, it kicks off a mandatory primary. This bill says, no, we'll reduce that, or we'll increase that to 25% before it kicks off a primary. And that's just to keep the expense of a primary off of there. And in this case, off the physical note. So that's the three things that this bill does.
I have scheduled Chairman Williams and Chairman Crawford to speak. Chairman Williams.
Thank you, Chairman. Thank you, Chairman Holsey. I think you, mainly as a point of clarification, so you can run as an independent right now and these rules don't apply, but if you wanted to run as a libertarian or otherwise, that these rules would apply. Well, I guess the question is if you wanted to run, then why wouldn't you just run as an independent?
Chairman.
That's what they've done in the past, but nobody knows what they stand for unless it's one-on-one that you're talking, but there's no platform and there's no party to tie them to. It's just independent. Actually, the Sixth Circuit U.S. Court of Appeals said in a case against Tennessee that this is what they said. Hold on. Too many parties could result in voter confusion if they're all labeled as independent. It is a puzzling proposition that voters should be less confused by a ballot listing numerous candidates without a party designation than by a similar ballot including party designations. So they're saying if you had a Libertarian and a Green and a Constitution all running on independent and they all got an I beside their name, nobody knows, who they're affiliated with.
Okay, thank you.
Chairman Crawford.
Thank you, Mr. Chairman. I have maybe two questions, but one to start with. This bill that we have before us today, was the dropping from 5% to 1%, is this the exact same bill that came before us last year that failed, or has there been changes in this?
No,
bill?
this is pretty much, I'm sorry.
Go ahead,
This is pretty much the same bill, yes.
Thank you.
Any other, Chairman Shaw? Oh, Representative Shaw. It's too many
Thank you
chairmans
for
on
that
this committee.
promotion. Thank you for that promotion. And I've been looking at this, and to be honest, been lobbied a whole lot on this. I really have. Here is what I'm wondering. I think in Tennessee, you got Republican, Democrat, and Independent. And to be perfectly honest, that's about the way Tennesseans think, out of one group or the other. They either a Democrat, they're Republican, or they are an independent, which you can choose either one right now. Let's just say Libertarian or Green parties. I don't know which party would come closer to thinking like my party or your party, I don't know. But to add another party, to me, really takes away from all of us, from your party. When you put, somebody cut my mic off there, when you put a name on the ticket, if it's a Republican and a Democrat, an independent, Green Party, Libertarian, or whatever, people have tendency to vote with their group more so in some ways than they do for the character of the person that's on the ballot. So I think what we're going to do is split the voters up more. And we're already facing issues right now with the voting. And I mean, I know you know that, a whole lot of issues right now. And I think we're going to create more havoc by adding another party than we are if you just look on the ballot, and if you are Republican, you like this guy, this lady, or if you're a Democrat, you like this fella or this lady, you're an independent, don't like either one of them. But when you add that other party, then you're going to take votes away from other people that really think and believe the very same thing. I just don't, I'm trying to figure out, why do we need another party with the system that we've got right now? And that's with all due respect. I appreciate your efforts here, but I just don't, I can't understand what we are accomplishing.
Chairman, I know I usually, it's, I guess you call it free roaming. I feel if a speaker is up, they can answer the question without my permission, but you, please go ahead.
Okay, thank you, and thank you, Representative. But the whole point of it is twofold. What the Constitution says is equal access no matter what party. By the way, there have been 40 minor parties in the history of the state of Tennessee that played significant roles in elections and campaigns in this state since we started as a state, 40 of them. It hadn't always been Democrat and Republican. And it appears that in the 60s, the Democrats and the Republicans got together and said, let's make a law and lock this up so that it's only a two-party system from now on. And from what I can hear in the history of it, it was because there was one guy running for governor, and he kept running every time, and they just got tired of it, so they wrote this law where he'd have to have 56 signatures to run. But the other part of it is that's the whole face of a republic and a democracy. If you use the word democracy, that's the whole face of it, is that people have choices on who to vote for. And it's the same thing here. I can't see a party being hurt by this. Well, I can see in one case where you might split the vote. Let's say that a Marxist socialist party lines up. You know, that might split a vote a little bit. But at the end of the day, it's constitutional. And at the end of the day, the citizens of the state having equal access to a ballot and who the people are that run, and I think far outweighs any other problems with it.
Any other questions? Seeing none, we proceed, excuse me. Oh, Chairman, okay. Seeing none, we'll go ahead. I don't know where Representative Williams went. His stuff is still here, so he doesn't have to take a call. Seeing none, we will proceed to vote on the bill. All those in favor of the bill say aye. All those opposed say nay. Nay. Bill fails with no. Sorry,
Well,
Chairman.
Thank you, Mr. Chairman and committee.
Excuse me. Next up is HB 0806, item 4 by Representative Powell. Do I hear a motion? Motion. Second? Second. Have a motion second. Please proceed with describing your bill.
Thank you, Mr. Chairman and members. So this bill would simply allow for absentee ballot requests. Currently, you have to provide a full Social Security number. This would just make it so all you would have to do is provide the last 4 digits of the Social Security number when you go about requesting that absentee ballot. And I think this is a very important bill for a number of reasons. Social Security scams have been the biggest and number one most utilized government imposter scam, according to different federal trade groups. And the other thing to remember is, if you consider last year as an outlier, for the most part, the predominant voters voting absentee have been seniors. Seniors are also the ones that are most susceptible to Social Security scams, and so it disproportionately burdens seniors by having to provide their full Social Security number. Currently, it's the federal law, the only institutions that can ask you to provide your Social Security number are different institutions that involve financial loans and financial matters. Otherwise, no one is really asking for a full Social Security number. So I'm simply saying, I think when you go about requesting an absentee ballot, there's other information you have to put, your birth date, other ways they can look you up. Just make sure that says that it's just the last 4 of your social. And with that, Mr. Chairman, I'm open to questions.
Chairman Crawford.
Thank you, Mr. Chairman. I have one question for the sponsor. When you go to receive this absentee ballot, you have to give your name, your birthday, and your Social Security. Is that correct?
Correct.
If we take the Social Security out of it and just give the 4 last numbers, would that allow them to be able to do not a background check, but a check to make sure that you are who you say you are and you live and reside at the place you say you do?
Sure. Mr. Chairman, if I could, I think that many times when you are asked for the last 4 of your social, I'm asked that many times when I'm speaking with different financial institutions that I mentioned, where they have that on record, and they're able to look you up by the last 4 of your social. I understand there'd be a case of 1 out of every 9,999 where you might have repeat Social Security numbers, but you would still have different name, different birth date. So I think that we could have created a system where we could still look up by those last 4 and then narrow that down. But there's other ways to look people up in the system besides just the last 4 of the social.
Chairman Crawford.
My big concern here is on new voters. If you have new voters who finally reach the age that they're going to vote and they go and they decide they want an absentee ballot, they give the last 4, how are they checked to make sure that they are who they say they are and they live at that resident?
Well, I still think, you would have to confirm, being able to send an absentee ballot, right, and be able to just guess on somebody's Social Security number, you'd have to hit.
Well, we don't want to guess on Social Security numbers.
You'd have to be 1 out of 10,000 to pick the right Social Security number if you're going to create some sort of scam. And I would say that we already have laws in place that prevent against fraudulent absentee voting that I think have been effective in this state. But so you would still have the check of asking for the last 4 of the social. This would simply make sure that we're limiting the ability for there to be any sort of fraudulent activity, people having to give out their absentee ballot that could be, accessed or used in a nefarious manner.
Again, I've got real concerns that we can verify the information provided without having the whole Social Security as it is now. If you just give the last 4, like you said, it would be a guess. So thank you.
Representative Love.
Thank you, Mr. Chairman. Representative Powell, thank you for bringing this piece of legislation. With this bill, persons would still have to have voted in person first to then request an absentee ballot, correct?
That is correct. This in no way changes that component of the law that's already in place. So you would, in the chairman's question, you'd already have a situation where somebody has already voted and had to have voted in person and been verified.
Okay, all right. And this just will protect, as you said, the identity and integrity of the voter and protect them some more.
Yeah, this just protects, not only their vote, which we also want to protect, but also their financial and all the different things that come with identity fraud that you can potentially fall victim to by giving out your Social Security number.
All right, thank you.
Any further questions? Heard discussion. I didn't know if there was any more questions. Seeing none, we will proceed to vote on the bill. We are now voting on House Bill 0806. All those in favor say aye. Aye. Opposed, nay? Nay. Bill fails. I'm sorry.
Thank you, Mr. Chairman, members.
Thank you for your work. Next up is item number 5, HB 0722, Hakeem. Do I hear a motion? A second. Hear a motion and a second. Please proceed to tell us about your bill.
Thank you very much, Mr. Chairman and members. What this bill does is prohibits a county election commissioner from voting on issues that directly affect commissioners' family members, meaning if they are running for office. And what it asks or requires is that 30 days prior to the election that the commissioner would recuse themselves, and after those 30 days, leading up to the election, then after those 30 days, they would be reinstated to that position. Now, all I just shared with you was in a bill that I put forward in 2018. It did pass the House. Time elements would not allow it to get through the Senate. The only addition that we have here is that if the election commissioner themselves become a candidate, then essentially they would give up their position as a commissioner to run for election. The thought is that if not reality, perception of impropriety could take place if that person is a commissioner during the election. And I guess I use the term, well, that'll be for a number of months, probably, if that person is running for election. That's essentially the bill, Mr. Chairman.
Chairman Williams, were you wanting to? Yeah. Okay.
Thank you, Chairman. Thank you, Representative. I thought that the County Election Commission already had a rule in place like this. The reason why I'm saying that is I have a county election commissioner whose wife is a county commissioner, and he does not serve as the chairman during the 30 days prior. Is this already not in statute, or is that something they self-imposed?
Well, as I said, I can't address at this moment what happened before 2018, but in 2018, this bill did pass the House, and there was no, I guess, objection or correction from the Secretary of State's office.
If I may, to answer
I apologize.
of all the state election commissioners, they each, some of them, like mine and most of Middle Tennessee, is Donna Barrett. This has been her policy in all the counties that she oversees, that if, say, an election commissioner in Rutherford County is got their sons running for office, during that election period, they step down and a temporary replacement is appointed, then they immediately resume the position after the election. But while most of the state election commissioners follow this, it's not in code anywhere. That's just a policy that some of them have been following, and the local election commissions have been abiding by since they report to that state election commissioner. So that's just the way we've been doing it in Rutherford County for a while now, so this would just make it applied across the state.
Okay, thank you.
Yes, sir.
One question, since you added if you're running for office personally,
Yes, sir.
is this also they temporarily set aside, then if they lose the election, they resume it?
Now, the way we have it written, that person forfeits that position. The thought being, I guess you could say they have, maybe inappropriate, they have to have some skin in the game, and that it could be deemed inappropriate, well, perception, that some hanky-panky is going on to allow something of this nature to transpire.
Let me ask legal, since the last year Ethan advised you on, you were asked him office some certain things,
sir.
and I even
Yes,
told
sir.
you about some things. Is, since this has been amended, is it still the practice of non-candidates to be immediately resume their position after the election of their relative?
I don't know, but I'll check on that. I don't know what the
Because
answer would be.
I think that's what it was last year. I wanted to make sure that if we temporarily asked a election commissioner with a conflict to step aside, then they resume, and the state election commissioner appoints an interim, and then they resume their position after certification. I want to make sure that's still in there and we're not just permanently dismissing them.
Yes, sir.
If we could, I guess should be proper procedure, we've got to recess for a few minutes while the legal looks that up.
Yes, sir.
We'll do that. We'll go into recess for legal to investigate, and we'll come back in what, 5 minutes?
Thank you.
Oh, I'm sorry, I didn't see.
But is that pursuant to?
That's the only. I'm rolled the bill 3 times, is it go to the table or go to the clerk's office? It's the number calendared, I believe, not the rows. Is that correct? Which would, per the rows of the committee, which would end up being about the same anyway. If it was calendar or rolled, you're going to be on 3 calendars, so. I would, and while we were out, we asked the State Election Commission as well as legal to answer a question of the committee had on your bill, since it is slightly different from last year and it's been a year since it ran that people have forgot about it. The original intent of the bill last year, and we believe this year, is that any election commissioner whose relative is running for office during that election period of 30 days, they would step down temporarily, a replacement would be appointed, then after the election is certified, they would then resume that position automatically.
Yes, sir.
Which is the practice in some counties now among some state election commissioners. In addition, your bill added that if you are a candidate yourself, you are permanently removed from the election commission at that time.
Yes, sir.
Which is the law today.
Yes, sir.
I believe Representative Hoseclaw had an additional question about resuming, and you might want to state that.
Thank you, Chairman. That's basically all it was if you run for office and you don't get it, then I would like to see where they actually get reinstated back in the.
As an election commissioner?
Yes.
Now, Mr. Chairman, I guess that's up to the board or the commission in that community. What I mean by that is that I think someone has stated, if the board is so inclined, it can reinstate that person, if that's what you mean. Am I correct on that?
Does the state election commissioner, Mark Goins here, do you feel you need to come up to clarify that?
Okay.
Going out of session here from Mark Goins, Director of Elections, State of Tennessee.
Currently, they are not reinstated if they qualify as a candidate. So once an election commissioner, so existing law, if someone qualifies as a candidate, they are immediately disqualified. So it creates a vacancy. So the State Election Commission fills that vacancy. That individual that qualified for office is not guaranteed to be placed back on. It will be up to the State Election Commission. And of course, the statute says that the State Election Commission does consult for recommendations from the General Assembly. They don't have to take your recommendations, but in most of the time, 9 times out of 10 they will. Sometimes the senator won't agree with a House member, and you have to make those calls. But in the instance you're talking about, there would be input from a legislator if they wanted them back on. So I lose, I'm a candidate, I run, I'm automatically disqualified. The State Election Commission is going to fill that vacancy, so the Election Commission can go through with its duties. At the conclusion of that election, if I lost, it's going to be up to the State Election Commission and the person that was appointed, because that person that's appointed under existing law would have to resign. This statute doesn't address that. This statute does address if a family member runs and you're automatically reinstated. This would not reinstate that candidate. Does that make sense?
Yes, sir. Yes, sir. Thanks for your explanation.
All right, thank you.
Representative Shaw.
So for me to understand what you're saying, his bill really has nothing to do with that. That's already the law.
That's right. I think what happened here is when the legislation was being drafted, they deleted the section and then they put stuff that was already in the section back in to clean it up a little bit, and that's what happened here. That is the existing law today. If an election commissioner qualifies for office, they're disqualified, vacancy exists, the election commission fills it, that person is not reinstated unless the state election commission does so, if another vacancy is created by the resignation of the person who replaced them.
Thank you, sir. So his bill is just dealing with the people who are serving on the election commission who will temporarily step down if somebody in the family is running, as he explained it, but once it's over, if they lose, then they can automatically be reinstated without coming back through the election commission, legislation, all that. Am I to understand that?
Yeah, and I think a good way to look at this is if there is a candidate that runs for office, there's not necessarily an expectation that you're going to be reappointed. Here, if I'm on the election commission and my wife were to run for county commission, I will step down, but there's an expectation I'm going to be placed back on. It's only temporary. Where the
Okay.
other could be permanent, may not be permanent. That's
Okay.
correct.
Thank you. Thank you, Mr. Chairman.
And one other question on the, since that's already state law, but he's restated again in his legislation. If someone does resign because they're personally running after the election, let's say they lose, there's nothing prohibiting them if the position's still available from being reappointed.
That's correct.
Okay. Any other questions or comments or any other confusion? Please express it now. I see none. I guess we will go back into session. Thank you, Mr. Goins. We're back in session.
Thank you, sir.
Representative Akeem, you got any further comments?
No, sir, I didn't know if that meant you might
Any
take a
other
vote.
further comments from the committee? Any need to roll or any other questions? Representative Shaw?
Thank you, Mr. Chairman. Do we need to roll now, having cleared that up? Do we need to roll, or can we just?
Well, is there, I don't see of any, no, I'm getting no, I don't have any questions, so.
Can I make a motion that we just go ahead and go back?
Yes.
I'd like to make a motion, then we just take it back up and pass it up or down, however we'll do that.
Calling the question.
Yes, call the question.
All right. Any objections? All those in favor say aye. Aye. Opposed, nay? Nay. Ayes have it. You proceed on to full local.
All right. Thank you, Mr. Chairman and members.
The next bill, item number 6, HB 1276 by Representative Griffey, has requested a one-week roll. And rolls are honored in my committee. Let's see, item number 7, HB 0209 by Representative Wright. Vice Chairman Wright? There you are. Do I hear a motion and a second? Motion, second? Please tell us about your bill.
Thank you, Mr. Chairman. This is House Bill 209. Let me read just a little bit of what I have here prepared before me. Generally, under present law, in order to vote, a person must be registered as a voter of the precinct in which the person is a resident. And if provided for by municipal charter or general law, may also be registered in a municipality in which the person owns a real property in order to participate in that municipality's elections. If a municipal charter provides for property rights voting, persons may vote based upon the ownership of an individual tract of property. Now let me back up for just a second, and there are several means of which you can own property. You can be the sole proprietor. Your name is on the deed. Be a partner with your sister, and two names can be on the deed. You can be a corporation, and someone still owns that property, and their name could be on the deed. And this goes on to about 9 different types, I think. What this bill adds is that if a municipal charter provides for property rights voting, the members of an LLC chartered in the state of Tennessee that owns property in the municipality would be entitled to vote, provided that only 2 members may vote for that LLC based on an individual tract of property. The individuals voting are residents of this state. And then the catch-all, you can't vote more than once in that election. With that, I stand for questions.
Any questions on the bill? Representative Shaw.
Thank you.
Yes, ma'am.
Thank you, Mr.
Excuse me,
Chairman.
my mic wasn't on. Representative Shaw, you recognized.
Thank you, Mr. Chairman. Thank you. And to the sponsor, certainly, I have a whole lot of respect for you, a whole lot. But I'm wondering, could this just not make it easy for people who live outside of the municipality to decide who would be mayor and all those things? Because, I mean, if you take a large city, you're going to have maybe 200 or 300 LLCs or business owners who could come in and really decide who be mayor of that city over and above those people who actually live in that city. If I'm reading this wrong, help me with, because that's what I see here, that the outsiders who live outside of the city will determine who runs the city over and above those who live in the city.
Chairman.
The issue that you raise is about the election of office holders. I believe that the intention of my bill is more broadly directed at: you own a piece of property, you are paying property tax, you are being zoned, you need the ability to participate in elections, maybe a lot more on other issues than just the election of the people that are going to run the city.
Representative Shaw.
I get that, but I'll just take a small city, a town where I'm from. I'm from a little town where there's a little over 5,000 people. And there are several businesses in that town. And if every business owner vote, they could really determine a city election. I still think it would be a detriment to the people who live in that city to be able to make a real decision about who they wanted to be the mayor or city council person or whatever over and against the business owners, because I have a business downtown, but I live out of the city. And so I could help determine who be the next mayor rather than the people who live on the west end or east end, south end, or whatever. So I'm still trying to comprehend how that would not happen. But thank you for letting me talk. And if you want to respond to that, I'll just shut up and let you respond.
Excuse me, I'm getting tongue tied. Representative Wright.
So the situation as it currently exists, there are already folk that are only voting because they are property owners. This is to level the field between an LLC and 9 other entities that already have the right to vote, provided the municipality extends that right to vote to non-resident property owners. This is not an attempt to bring in more voters. It's an attempt to level the playing field based on the ownership status.
Before I recognize Representative Love, I had one question, take personal proof. I believe I was asking legal. I believe this is, it needs to clarify, and you may have said this, but I missed it. This is only in cities and their charters that currently allow property rights voting, which is already allowed in most cities, that if you own, say if you reside in Memphis and you own a lot in Nashville, that you can vote. If it's permissible already in the charter to allow that, this just extends that right to LLCs rather than just individuals.
Correctly stated.
Okay. Representative Love.
Thank you, Mr. Chairman. Representative Wright, thank you for bringing the bill. I do have a question about multiple pieces of property owned by the LLC. In that instance, what happens?
As I think I've got it written in my notes. I'll look back and see, but I'm going to say it this way. The LLC can only vote on one individual piece of property. It cannot vote multiple times on multiple parcels.
Okay.
Representative Love.
Thank you. You mentioned 9 other entities that currently have the right to vote. Did something happen where those other entities were able to vote and an owner of the LLC was not able to vote? I'm trying to get the genesis of where this bill came from.
That is exactly where this bill has come from. The other entities that have ownership by name on the deed, if the municipality allows property voting rights, they're okay. They vote today. They register only in the municipal election one time. They can only vote once right now. So this is allowing LLCs where the real estate is owned in the name of the LLC, not an individual name of a real person who can register to vote.
Representative Love.
Thank you, Mr. Chairman. And I'm just trying to get clarity on this. Those other 9 instances, is it a person individually, or is it a different form of ownership? Is it a corporation? Is it?
That's a good question, and it has to be that ever how the ownership is listed, it has to be an individual's name. If you have the business and your name's on the deed, you're already covered. If you and I are a partnership and our names are on the deed, we're already covered. If the whole bunch of us here have a corporation and someone's name is listed on the deed as owning the property, and I think that's only up to 2, doesn't matter how many people could be named on the deed, but only 2 people could vote in that municipal election based on a corporation. And then there are other, I cannot name all of the other forms of property ownership.
Okay.
Representative Love.
Thank you, Mr. Chairman. And I guess I was trying to figure out, this will have statewide implication.
Yes.
And I was trying to figure out if this was a situation that was happening in one particular space that you're speaking about, if you could do that for that one particular city and resolve that issue.
No.
Okay, so it's got to be across the state. It's got to apply statewide. It's what I'm hearing you say.
That's correct.
I have concerns about LLCs. There's nothing requiring the owner to live, or the owners in this limited liability corporation, to live in the county. Can the LLC ownership change? I'm not familiar with, I don't have any law experience, so I want to know, can that change in the course of time?
The partners of an LLC can change over time, I would say.
Last one, Mr. Chairman.
Yes, go ahead.
Thank you. So that's my concern, is that you may have a situation where the LLC ownership and partners may change, and you then have persons who want the city to go in a particular direction, and they increase the number of LLCs in that particular city. They buy up property, and they stack the deck, and they start to dilute some of the vote. That would be my concern, particularly when you're talking about, to your point, making decisions not just about who is going to be the mayor in that city, but then who's going to be the school board members. And I understand your intent, and I respect that. Those would be my concerns about persons who might go down the wrong path with this.
Sponsors of the bill have any other comments?
No, I stand for question.
Okay.
Further, and ask for your vote, affirmative vote.
Any other questions on the bill? Seeing none, if there are no objection, we will go ahead and vote on the bill. All those in favor of HB 0209 by Representative Wright, say aye.
Aye.
Opposed, nay. Better take a roll call. I couldn't tell.
Representative Holsclaw? Representative Love?
No.
Representative Manis? Representative Shaw?
No.
Representative Williams?
No.
Representative Wright?
Yes.
Representative Crawford?
No.
Chairman Rudd?
No.
3 ayes, 5 nays.
The bill fails to progress to local. Let's see, is there any other comments? Announcements? Seeing none, we are hereby adjourned. Thank all for attending.